the Legal Aid Committee, we're going to go ahead and get started. Happy New Year. Happy 2018. Hopefully you're off to a good start. If you are not off to a good start, I highly recommend that you take a look at the Legal Aid Committee selected highlights. It will brighten your day. The people in this room have been doing some incredible work. I didn't get a chance to look at it until I sat down here about 10 minutes ago and started flipping through it though. And I think we can be proud of our committee, proud of the nonprofit legal services here in Chicago, and proud of the work that we're doing together. So congratulations to everybody. Let's give ourselves a little... Given what's going on nationally, I think it's always good to sometimes look locally and celebrate some of our wins locally. So, before I forget, please enter in your CBA member number in the little computer right there. That's how you get CLE credit. So if you leave here and you email Angela or anybody else in this Chicago bar, you're going to give them a headache. Because that's not how this works. You do it right here by plugging in your CBA member number. So please do that before you leave. For those that don't know me, I'm Cliff Nelson, the Executive Director of Lawndale Christian Legal Center, the Chair of the committee this year. My co-chair, Rebecca Farachoki. I'm sorry, I just tortured your name. Let me try that again. That was really bad. That might have been record-breaking bad. Rashid Farachoki. She's our vice chair, and then Beth Johnson is our legislative liaison. So today, as we do every year, this is the annual Legal Aid Highlights meeting, and we could have brought in a number of organizations to be on our panel today, but we've selected three that I think provide us with a good overview of some wonderful things that are happening in the city of Chicago. So I want to thank everybody for first submitting your highlights to the CBA. It's nice to see everybody's good work. Thank you to our panelists for being here. Tom Yates is our third panelist. He's going to come in and slide in the middle of this. He is third on the list, so that's okay. But just want to thank everybody for sending in their highlights. Some of the highlights, a couple of what you're going to hear from today, is ending the Illinois budget crisis. Thank God for that. Through policy advocacy and impact litigation, you're going to hear from more about that. And the work that we've been doing to help our immigrant neighbors, which, as we know, given the new administration federally, has been a major concern. The last thing I want to do, let's see here, is it the last thing I want to do? I apologize. Is just thank you our speakers. So let me go ahead and introduce our speakers. So Barry Taylor is the Vice President for Civil Rights and Systemic Litigation at Equip for Equality. He's worked there since 1996 at EFE. He has overseen many of the individual and systemic disability discrimination cases, including successful federal ADA suits against the National Board of Medical Examiners, the Chicago Police Department, and the Chicago Transit Authority, and he is currently co-counsel in 5 ADA class actions. Our second panelist is Sarah Block. She's the Domestic Violence Project Attorney at the Family Defense Center. Sarah was previously a Skadden Fellow at Legal Assistance Foundation and a 2-time Skadden Flom?
It's a follow-up grant from Skadden,
okay.
Yes.
Incubator grant recipient, all focusing on the intersection of domestic violence and child welfare. And then third is Tom Yates, who's the Executive Director of Legal Counsel for Health and Justice, and he's honored to be on the panel here with Sarah and Barry, both incredible advocates and be a part of the Chicago Legal Aid community. So, without further ado, did I miss anything, Angela? We're good? Okay, I am going to turn it over then to Barry.
Thanks, good afternoon. So I'm here to talk to you about an initiative that we worked on the last year and a half or so called the Voting Access Chicago. And this actually started back in 2016. The Department of Justice under the previous administration had a priority of ensuring that polling places were accessible to people with disabilities. It's a great thing. What they did was they wanted to partner with the U.S. Attorney's offices across the country to look at the accessibility of polling places. And they included reaching out to our Chicago U.S. Attorney's Office, and their point person there was Patrick Johnson, who I know a lot of you in this room know. And so what Patrick and his team did was they went out for the March 2016 primary and did some accessibility testing of a sample of polling places, about 100 polling places. And that sampling showed significant accessibility barriers here in Chicago for people with disabilities. Some of the barriers they found were physical accessibilities, people who might be using wheelchairs. Maybe they weren't physically accessible in the entrance or in the approach up, lack of curb cuts or steps, or within the polling place itself. There might have been also issues regarding inaccessibility of parking for those polling places that provided parking. And then there's also a requirement under the Help America Vote Act that every single polling place has an accessible polling machine, that is for people who are maybe or blind, to be able to access the ballot, the touch screen, so they can vote independently and privately. You probably have seen those in your polling places. And some of those weren't working, or the polling judges didn't know how to work them. And so there are a variety of problems they found. A majority of the polling places they went to had some barrier in existence. And so the protocol for DOJ at the time was to approach the polling place authority for Chicago, the Chicago Board of Elections, to see what they would do about it. And interestingly, across the country, some election authorities were very adversarial in their approach and said, you know, you're wrong, DOJ, and litigation ensued, Texas being the most primary example. But to their credit, the Chicago Board of Elections said, we want to work with you, we want to collaborate and address these problems and avoid litigation. And they were actually surprised by the number of barriers that were identified, because what they had been doing was relying upon a state law that provides what's called curbside voting. I don't know if people are familiar with this, but if an election authority deems the polling place inaccessible, they can't easily make it accessible, they have sort of a second alternative, and that is to bring the ballot out to the person who can't get into the polling place and let them vote at the curb. And what DOJ said was, well, that's a nice state law, but we think that's in violation of the Americans with Disabilities Act. Specifically, the ADA talks about what's called meaningful access, which means that you have to have meaningful access to government programs, and that even though these individuals were able to vote, they weren't being denied the right to vote, it wasn't really the same experience for non-disabled people. They weren't able to vote independently and privately because people would have to come out to them for their ballot. Or if the touchscreen voting was broken, CBOE would help people out to vote for them, to help them vote if they're blind, but again, they wouldn't be voting independently and privately. And so because DOJ took the position that the Board of Elections wasn't following the ADA, even though they were complying with the state law, that was really where the conflict arose. And CBOE said, okay, we get it, and we want to fix this. And so that's where Equip for Equality came in. CBOE reached out to us to try to help figure out how to fix this. And what DOJ said is, before we want to finalize our agreement on how you're going to fix this, we'd like to get a clear view of are the problems that we identified really indicative of the broader polling places. And so what we'd like you to do, CBOE, and CBOE said, this means Equip for Equality, is to actually survey all of the precincts in Chicago. And for those of you who aren't aware, there's over 2,000 precincts in Chicago. And this was 3 months before the election. And so we're like, wow, that's a lot. So what we realized was this wasn't something we could do alone. We obviously got all our staff on board to assist with this initiative, but we needed more. And so Olga Pribble taking the lead, we recruited a lot of pro bono folks to help us. A lot of our typical pro bono partners, corporate legal partners, or the law firm partners, but that wasn't enough, and so we actually had to delve into the law students, got a lot of the law schools on board, and even some college students at UIC. It was interesting, though, when we reached out to our traditional partners, there were a few that pushed back and said that sounds great, but we can't do this because we view this as a partisan pro bono project. And we said, well, wait a second, it isn't partisan, it's about getting access to the polls for people with disabilities. And they said, there is a perception from some that is partisan because it's a Democratic Party concept to expand voting for people with disabilities and other disenfranchised people, which was surprising and troubling in and of itself, but that's the reality of our world. So that meant that we had to delve a little bit deeper for our pro bono recruitment. What we did for the CBOE was to first of all train their trainers who trained the election judges to make sure they understood their responsibilities, because a lot of this can be done by the polling judges while they're there. We also worked, put together an FAQ and a checklist so that when polling judges set up their polling places, they could make sure that they could do whatever they could do to make sure there was accessibility there. But the big thing was training all these volunteers. And so what we did was we went to the universities and to the law firms and the corporations who were partnering with us and did trainings at their place. And then a lot of folks came to our office when they weren't affiliated and were just wanting to volunteer with us, even though maybe their firm or their corporation was involved. And the cool thing about this training was we actually had tools and visual aids that we were able to use. So just in case you're interested in joining this initiative, you get to work with tools when you do this. And so you learn how to measure different things like the width of doors and that sort of thing, the length of ramps. You get to use this cool pressure gauge to make sure that doors aren't too heavy for people with disabilities when they're trying to access them. And best of all, you get to use this electronic level, which just, not just a little one that we use for our pictures, right? No, this is electronic. And you can actually put it on ramps to make sure that the slope isn't too steep and that sort of thing. So people like to play with those and do those. The other thing that was cool is we were able to get professional responsibility credit for the training. And so obviously people are always looking for the ethics training, and we were able to thread that needle and get the MCLE board to agree that this was worthy of that. And so that helped, I think, get folks together. So we went out and we did all the trainings. The reason why it was so important to get so many volunteers is that we had to actually do all this on election day, right? Because there's one day when the polling place is a polling place as opposed to it's just a school that day or it's just a church that day. And so we need to be there on the actual day to see how it actually worked and made sure that it was accessible. So that's why we needed so many folks. So after we did that, we confirmed what the Department of Justice had already determined, and that is that there were these significant barriers and that DOJ's surveys weren't an aberration. And after that, we then worked with the CBOE and DOJ to negotiate an agreement. And basically what came out was really an exciting systemic change. And that is the CBOE has agreed that by the 2020 presidential election, which can't come soon enough, 100% of the polling places in Chicago will be accessible. And so that's the commitment that the CBOE has made. It's a huge commitment. And what we did after we did the training, the surveys, was we analyzed those, every single polling place, every single barrier, and we said, okay, for each barrier, is there a temporary fix? So perhaps there's steps, can we put in a temporary ramp so by the next election, folks with disabilities can get in? Is there a permanent fix that we can do? Can we build a ramp, or can we maybe modify a door so that people can get in? And if there are situations where an accessibility issue cannot be resolved, can we identify a new polling place? Which is challenging in Chicago because there's sort of polling place deserts. We hear about food deserts. There's sort of the same sort of thing in Chicago. There are a lot of places that it's just hard to find a place. And of course, if there's not a City of Chicago related entity, you have to get sort of the kindness of private sector to help. And a lot of folks just don't want people tromping through their places. And as you can imagine, with the way things are with schools these days, schools are more reluctant about having this sort of situation because of security and those kinds of things. So that issue is challenging. So the more we can make the current places accessible, the better. So that's what we're working on now. We're working with not only the city, but the city-related agencies like the CPS and the Park District and the libraries where a lot of these polling places are. So we're now at the next stage, because this is going to be going on for another 3 years. And we are going to be surveying all Chicago polling places in the March primary. And as you can imagine, we need more volunteers, and we would love for any and all of you to join us. On your table, there are a couple things. One's a flyer that sort of explains the project. We also have a sign-up sheet if you're, already ready to jump on in. Feel free to put that on, and frankly, this commits you to getting information. You can obviously check your schedule, make sure it works. The primary is on March 20th. For folks who might have a conflict that day, we do have some limited training, some limited polling place surveys for early voting places. So we also go to those places as well. And the training is about an hour and a half. So you get the professional credit, and then the actual pro bono opportunity can be either a half day, about 4 hours, or a full day. So if you want to just do half a day, that certainly would work out as well. We do have a new person on board whose primary job is to work on this new initiative. We have Tracy Hartley, if you want to stand and wave. Some of you may know Tracy. She was the bureau chief of the Illinois Attorney General's Disability Rights Bureau, so she has a lot of experience on accessibility. So she did a lot of this as a volunteer for us last year, and now is rightfully getting paid for her work. And so we're glad to have her on board. The other cool thing that's come up is we've developed an electronic survey. So before we were sort of managing all this paper along with our handy dandy tools, and now we have it on your phone, so you can access the survey on your phone. And so you can go through, we think it'll be a lot quicker, and what you can also do is you can access through your phone the previous survey. So you can say, oh, this place has a problem with a heavy door, let me see if they fix that, or this had some stairs or some inaccessible parking. So that'll allow us to track it more easily as we go forward, because we're basically going to be doing this every election, primary and general election, through the presidential election in November of 2020. So we hope that investment will really make a difference. So I think that's sort of it in a nutshell, and I'm happy to answer any questions anybody has. Yeah?
I assume you don't have to be a lawyer to be a volunteer.
Yeah, in case you couldn't hear the question, you do not have to be a volunteer, you do not have to be a lawyer to volunteer. In fact, like I said, we had law students and college students doing this. We actually had some folks who did this as a project with their family, so we had some spouses do it, we had some people bring their kids, and that's all good. We get you what's called a credential from the Board of Election, which allows you to go to polling places that aren't your own polling place. We obviously try to accommodate people as much as we can to go to places that are convenient to them, located-wise. Obviously, the city is a big place, and so we ask people to maybe go some places outside of where they live, but obviously we work to accommodate that as best we can. Yeah?
How does the training work? Is it at your office, or will you go to firms or companies?
Yeah, so we went to a lot of firms. We'll go to firms, or if they're legal aid organizations that want to do this, we'll come to you for that. And then, as I said, if people don't have an affiliation, they will have in-house trainings as well. We'll be setting those up. And Tracy's contact information is on the bottom of the flyer, and she's happy. She's going to be taking the lead now on the trainings as well as setting them up and the volunteer recruitment.
Because we're getting more and more people contacting us wanting like a one-day.
Yeah, right. Bite-sized kind of thing.
Yeah, like a company-wide day of service or something. That's really
Yeah, that's a great fit. And then the other thing we had pitched was we had said to firms, this is a great thing to do with your clients, your corporate legal folks that you work with. And some firms took advantage of that. Again, we had some corporations who felt that this was quote unquote a partisan activity, so they didn't engage. But it is a really nice sort of bite-sized kind of thing, and with the professional responsibility credit, it kind of takes it to another level too. Yeah.
Very great work. This is just fabulous. Is there a way to get electronic copies of this?
Yes, absolutely.
Just
So
email me, I'll be happy to share that with you.
yeah, and I don't know, Angela, if we can send that to you and you can circulate it, would that be
Yeah, I'm
easier?
going to send the highlights a little bit around after, so I can attach that as well.
Okay,
Yeah.
so Tracy will send that to you, Angela. Great, thanks.
Has there been a similar commitment from Clerk of Work to look at the suburbs, or?
We talked to DOJ as far as whether they're going to go beyond this. I mean, they started with the city, and I think it's a big thing to tackle. And what they're hoping is that, we tried to do some press around this, and I think they'll continue to do that to hopefully get people on board and maybe start thinking about this before DOJ comes a knocking. I think they're starting with Chicago, but they're certainly looking at other parts of the state. Chicago, I think, is probably because of the old aspect of its architecture. There are probably more barriers than there are in the suburbs, although there certainly are barriers there as well. Any other questions?
This is already off and running, right? So a change in the DOJ leadership isn't going to change.
Yeah. That's a great question. We were questioning that as well. We actually signed the agreement after the administration changed, and because we had said, we got to sign it. And it didn't get signed until after, but it got signed. And so, so far, no one is saying, stop making polling places accessible to people with disabilities. So we're hopeful that that's not going to get reversed, although no guarantees, I suppose. But there is an agreement that's signed, so they would have to actually revoke the agreement as opposed to just say, we're not going to go forward with this as an initiative. Great, thanks.
Good afternoon, everyone. Once again, my name is Sarah Block, and I'm the Domestic Violence Project Attorney at the Family Defense Center. And I'm excited to share with you today about an innovative and collaborative project that we are piloting with DCFS regarding families experiencing domestic violence. So I think I'll give you a little bit of a history of how we got to this point, where we are right now, and then hopefully where we hope to come in the next few months and then many years to come. So for the past 10 years, we have been trying to improve the way that DCFS responds to families experiencing domestic violence. Their approach historically has been that it's very difficult to understand the dynamics of domestic violence. They misinterpret the different roles that parents are playing. They often have a very punitive response to what we're calling non-offending parents, the adult victim of domestic violence. That results in oftentimes losing custody of their children through the juvenile court system, placing children with the abusive parent or their family, and also indicating them with findings that cause them to lose their jobs, thus making them more dependent upon breadwinning mothers. So there's a panoply of problems that we've identified over the past many years. In response to these problems, we had a litigation strategy to try to improve the way that DCFS was responding. That was through the work at LAF as well as the Family Defense Center, which resulted in a Supreme Court case, which you probably have heard about at some of these updates, called the Julie Q case. It resulted in the reworking and the redrafting of the rule governing the neglect allegation regarding domestic violence in Illinois. And we're really proud of where the law is on paper, and it's very strong. And on paper, it says that a non-offending parent is presumed to be not neglectful so long as she took precautionary measures to protect her children and reduce the risk of the domestic violence posed. It's a really strong rule. We have a very good sense of what's happening across the country, and our rule on paper is very strong. Unfortunately, like in many situations, a rule on paper does not necessarily translate into practice. And so nearly 5 years after this rule has been in place, we are still seeing the same issues that I just highlighted in the beginning. But we realized that in order to get the systemic and long-standing change that we wanted, that working collaboratively with DCFS was the better approach rather than further litigation. And we felt we sort of hit our wall with litigation. We tried a different approach. And that approach has been that 2.5 years ago, we formed a coalition called the Domestic Violence Child Welfare Resource Coalition, which is quite a mouthful, but each word is significant. And it was a coalition of over 30 domestic violence and sexual assault legal and service organizations. Many of the organizations have participated in our coalition. And the purpose was to come together to figure out what we think needs to change and try to be a part of that solution. It was at a time where the director of DCFS, George Sheldon, was very receptive to the community voice and wanted to come forward to tell us, what do your constituents, the families that you serve, what do they need and how can we be better? So we spent about 9 months as a coalition with the support of the National Council of Juvenile and Family Court Judges. It's really looking at the entire country, thinking about what programs are happening in other states that we could bring here. We did this in partnership with the Illinois Coalition Against Domestic Violence, as well as with the Chicago Metropolitan Battered Women's Network. So we came to DCFS with a proposal of co-locating domestic violence advocates in DCFS field offices. And we were modeling this program after a statewide program in Florida. It was a nice coincidence that Director Sheldon came from Florida and was had a much affinity for the work he did there, and luckily Florida had a very strong statewide program. So we were able to travel with DCFS leaders and administrators down to Florida a year ago to observe Florida's program statewide. We were able to see it in 3 different locations, and we all walked away recognizing how impactful this program can be. What we saw is that it was the collaboration between the advocacy community with DCFS, which is often a very insular and very powerful arm, and when they would collaborate and trust an outsider to bring a perspective forward, it really caused a systemic change in which non-offending parents were no longer seen as perpetrators, that there was a much deeper understanding of domestic violence and what families need to recover from harm, and much stronger outcomes for children. I also saw, which sort of was a hypothesis that I had, that when you can collaborate in this way on one topic, it actually impacts and improves practice across other problems when families are experiencing them too. So it has sort of a residual effect beyond just families experiencing domestic violence. So we saw that this program was tried and true. Florida has over 60 co-located domestic violence advocates in each of one of their investigative offices. They are now expanding their program into their foster care and permanency organizations. And almost every domestic violence agency in the state of Florida is involved with the program. So it has sort of as this unifying a consequence also. So we came back to Illinois with the idea that we'd be launching the program and getting it off the ground. At that time, Director Sheldon decided he would go back to Florida, so we had leadership changes at DCFS. But in the meantime, we had brought a bill forward in the legislature, Senate Bill 646, which authorized our program. And we did this not because we needed the bill to get the program off the ground, but because we did anticipate leadership changes down the road, and we felt that if our program was codified in statute, it would be a lot harder to ignore by a future director. And we actually, our bill, we did it in partnership with DCFS, which for anyone who knows the work of the Family Defense Center, that was a really significant thing that we were collaborating and actually brought a bill forward together and testified together, and that was very significant in terms of the partnership we were trying to form. So fast forward to the fall, we were working very hard with DCFS to get the program off the ground, and we were able to win a federal grant for the Children's Bureau, the Quality Improvement Center, to focus on a collaborative practice across the country regarding the intersection of child welfare and domestic violence. And what's so exciting about this federal grant is that for 20 years there's been a national model out there called Green Book. Some of you might be familiar with it, but it's sort of the Bible for child welfare intervention regarding domestic violence. And this Quality Improvement Grant is focused on taking the lessons learned over the past 20 years and really delving into the details of what elements of collaboration between child welfare and domestic violence, what about those elements are critical to any collaborative effort. And so we were really honored to receive this grant, especially because our collaboration was just starting. One of our other fellow recipients is in Massachusetts, and they've had a 20-year program of collaboration, a different model. So we were sort of at very different places in our evolution. But I think that the funders recognized that our collaboration was very intentional and that everyone was very committed to seeing it come to fruition. So that grant really focuses on research, so we will be able to establish the effectiveness of this collaboration in reducing removals of children from families, increasing stability, being much more strength-based, and hopefully leading to greater, better accountability. And so we are now on the precipice of our launch. Again, it sort of feels monumental that we have collaborated with DCFS in a way that we are actually partnering and working on this issue together. We are not starting in Chicago. We are starting in Waukegan, partnering with a safe place. Our hope is that this program will prove to be extremely valuable to the frontline staff who feel they really lack the skills, the experience necessary to handle the prevalence and the complication that domestic violence cases pose to them. And we hope that we'll be able to establish the outcomes also. And our hope and my dream is that we will be statewide eventually. I hope that we will follow this in the path of Florida, and that we can come back to another highlights in a couple of years and say that now we're in 10 different DCFS offices. And the idea, as I said, is to be statewide. And this idea of collaboration and co-location is really something that's applicable to other disciplines too. In Florida, they also have substance abuse counselors as well as mental health professionals that work in DCFS offices. So the model is applicable to those disciplines also. One thing just to clarify about co-location, we're using that term as a term of art. Oftentimes we think about co-location as someone doing their exact job in a different environment. We're conceiving of this position is actually different. The domestic violence advocate who actually works for a safe place but will be housed in a DCFS office is not doing their bread and butter work as a domestic violence advocate. They're not doing individual counseling or group counseling sessions. or other sort of forms of advocacy. Rather, they're really there to support the DCFS investigator and provide them with the expert consultation and coaching to effectively handle these cases. And it's a really important distinction that's taken a while for sort of many partners to sort of understand, because it's not your quintessential co-location. But we felt that by sort of having this interdisciplinary model, that's really where we're going to push the envelope, and it's the tension between the two that's based upon hopefully professional trust that will cause the best outcomes for children. And we see this as a prevention program. This is really a prevention into foster care. The stronger that we can make the front end of investigations to stabilize families and get them what they need, we are hoping that fewer kids will come into care, and we will save a lot of money doing it. So that's my update. I'd be happy to answer any questions. Yes.
You might have said this. Will the advocate be there every day?
A good question. The model is that they spend 4 days a week in the investigative office or the field office and 1 day back in their organization. Because of the federal grant requirements, it's a little bit more complicated than that, but there will be a domestic violence advocate in the office, the DCFS field office, 4 days a week. Great. Well, thank you very much.
I'm not Tom Yates, nor will I speak for him. He is caught in court, so we are going to call an audible here. For those that don't play football, that means I'm calling a play at the line of scrimmage. And the play will be anybody who wants to come up to the microphone and share their highlight for 2017. We're doing an open mic. And I will call on people. No, I'm kidding. Well, okay. I will model the open mic. So I think everybody might remember last year we did a CLE credit on the Restorative Justice Community Court. What is restorative justice? And the new court that opened up in North Lawndale. The good news is it opened up in North Lawndale in September of 2017. And so I would encourage everybody to come. And I mean, I know that's asking a lot. But if you can, the court is open every Thursday morning. It is being temporarily located in a community organization called UCAN at 3605 West Fillmore. I don't expect you to remember that, so come see me or email me if you want to go. If there was a group, if like the legal aid committee wanted to go and to do a planned event, just throwing this up, this is improv, open mic, just throwing things out, ready to come off my tongue. Then I would see Judge Sheehan and the community court coordinator Nancy Michaels and the staff, I'm sure would be willing to roll out the red carpet, give a little presentation. I am advocating for everybody to come visit because I am hopeful that this could be significant criminal justice reform. The Restorative Justice Community Court is a shared power unlike anything I've seen. It is nothing like 26 in California. The court process is literally deferred to community residents who gather circles based upon restorative justice practices and principles, and those most affected, those closest to the harm, those closest to the pain, actually resolve what is needed to dispose of this case. It's a deferred prosecution model. There'll be no jail, there'll be no criminal records for successful completion. And that circle, led by community residents, with community residents to determine the outcomes, is called a repair of harm agreement that is entered into the court and then court supervised. That's repair of harm agreement is completed. We're about to close our first case here in the next coming weeks. So it's been a success so far. I think there's ballpark, maybe, don't hold me to this, 30 cases that I would say probably about 10 to 15 have actually completed repair of harm agreements. The other ones are still in the process of doing that and completing the actual repair of harm.
First thing, I would definitely be interested in a field trip to go see that. That sounds really cool. And my other question was, what cases are eligible for this?
Yeah, good question. So it's 18 to 26. So it is a community court. It is in North Lawndale. So the catchment area is North Lawndale, but we also included the south parts of East and West Garfield Park. If I remember correctly, I think Lake Street might be the cutoff. But the idea is accessibility, local. So to qualify for the court, case has to rest occurs in that catchment area. It's really south part of East and West Garfield Park in North Lawndale. 18 to 26-year-olds, which is what I think makes this also something that could produce some very significant criminal justice reform, because there's a growing movement in Chicago to think differently about how to respond to emerging adults, given brain science, neurobiological development. I'm going to just stick to my legal stuff. Res ipsa loquitur. But brain development and developmental psychology and common sense says that 18 and 26-year-olds mature differently. So anyway, this court is creating different interventions from the systemic point of view for 18 and 26-year-olds. 18 and 26, nonviolent felonies is where they're starting, which means that they are all screened at bond court, 26 in Cal, and then brought to the RJCC, with one exception is there are some community referrals, mostly from the legal center, because we're the only community-based agency that has lawyers. And so we have cases at 26 in California that we've been getting out of 26 in California and into this court as quickly as possible.
Great.
Did I answer your question?
Yeah.
Okay, good.
How many nonprofits in the North Lawndale, Garfield Park area are involved with, I assume there's referrals
Yes.
or other supportive services as part of this
Yes.
court? How many groups are involved?
Ballpark about 20. So 3 years ago, a little more than 3 actually now, we formed a grassroots collaboration called the North Lawndale Community Restorative Justice Hub. It's people who live, work, or worship in the neighborhood. Out of there's about 28 to 30 members, if you will. About 19 or 20 of them are CBOs, community-based organizations, nonprofits, that provide services in housing, employment, mental health, mentoring, restorative justice, family wraparounds. There's churches, schools. So there is a broad network of services that are being linked, that the participants coming through the court are being linked to all these different service providers. And that's been exciting to see too, because we actually piloted this last year before we opened up the court with all those service providers. How well can we collectively serve 18 and 26-year-olds together? We piloted with 25, 18, and 26-year-olds that had cases at 26 in Cal. This open mic did not turn into an open mic. Anybody else want to share, or any other questions about the Restorative Justice Community Court, or anybody else want to come up and share a highlight of 2017? And you're going to regulate the time, because I have no idea what time it is.
Oh,
we're good.
okay.
Okay, we're good.
We can also end early, but there were some really great highlights. So, I mean, I have people who I would like to call on, but I won't.
But I will. You want to do legislative update? You don't want to pick on anybody? All right, we'll be nice. We'll be nice. We're going to start out 2018 nice. You're lucky. Angela's nicer than I am.
But I do encourage everyone, I'm intimately familiar with the highlights that were submitted, so there are some really, really great ones, and I encourage everyone to, I know it's, a lot, but to at least skim through them and see the great work that you guys are all doing. It's really, really great. So, really quick legislative update. So, we voted at the last meeting to move forward with 2 bills this year, which one was that it would change so that a notary was not necessary for court documents that are filed. So you would just do a certification under, and the other bill is the Plain Writing Act. So the idea that moving forward, things when the government is communicating with the public, it should be in plain writing, whether that's statutes or executive orders, etc. Both of those made it through our committee, as I said. They've now made it through the CBA's legislative committee. They were passed through. They now go to the CBA board for approval. And I think that's maybe next week, so fingers crossed. It's looking good that those will be part of our legislative package as a committee this year, which is really great. Continuing our simplification efforts for the public. So that's one. The other, the third bill that will be part of our package is the fees and fines reform legislation, again, from last year. Didn't have to go through the process as it had went through it last year. Elaine Neckeritz did retire. She was our Democratic sponsor. Representative Jean Gordon Booth from Peoria will be the Democratic sponsor for the bill this year, which is very exciting. She's going to be really great. She's very passionate about it. Representative Anderson, though you may have heard he is retiring, he is finishing out his term, so he will remain the chief sponsor sponsor and the Republican sponsor in the House. We are looking, there's going to be a little bit of a different strategy this year on the bill. I won't get too in the weeds on all of it, but one of the things that is that we'll be putting it in the House and the Senate at the same time to push through, which we didn't do last year. It's looking really good. We've resolved a lot of the objections that were out there. And actually, Representative Neckwitz will still be working on the bill. She's formed a lobbying firm with one of her former staffers who was the point person, so that's kind of, they're going to be working on it pro bono, so that's kind of a seamless transition of the people who are already working on the bill, which is great. If you guys have, CGLA will really be taking the lead on what I'm about to say, but if any of you have clients that have stories about how fees and fines have impacted their life, please let myself or Beth Johnson know. That's going to be a big push for testimony this year so that we can really put in front of the legislators the face to this issue. And so that will be another thing that we'll be working on this year. So those are the kind of the three things on the state level. We will be doing a Springfield trip again this year. I'll let you guys know when that will be. That will be joint with the Chicago Bar Association's Young Lawyers section. The ABA Day, the dates are escaping me, but they're in April. It's a little earlier this year, so if you're looking to go out to Washington and lobby on things like Legal Services Corporation funding, we'd love to have you. Please let me know about that as well. So we're ramping up. It's going to be, we're going to start in the next few months to see a lot more legislation and be going to the subcommittee for their opinion on things. I know that Melanie has a quick announcement, which is great because we have time for you to explain it.
I love talking.
Yeah, and and then after Melanie, any other announcements or other business we can do at that point. But do you want?
Yeah, sure. I don't know that it's going to be relevant for most of your practice, but I just wanted you guys to know that a law was passed. I'm Melanie from Legal Aid Society. I supervise the domestic violence team, and prior to January 2nd or January 1st, you could get an order of protection in all sorts of courts, in a divorce court, in a probate case, as an independent standalone LP, or in conjunction with a criminal case. And prior to January 1st, all of those processes looked relatively similar. You could go ex parte and get an emergency order, and then they serve the abuser, and he or she shows up, and you can get a long-term order, and it was all kind of the same. A law got passed in the fall to change that for criminal cases. And basically, my understanding is that it was drafted in order to encourage counties downstate where the state's attorney's offices weren't helping victims get orders in conjunction with criminal cases to encourage them to do so. And what it did is it got rid of the terms emergency, interim, and plenary and made a category of protective orders for people with criminal cases. Unfortunately, as what appears to be a drafting error, it also then got rid of emergency relief for complaining witnesses who need an ex parte emergency order of protection as a result of abuse. Oops. So right now, if you're so for counties that were helping victims, and that includes Cook County, you used to be able to go to 555 West Harrison and say, I've been a victim of abuse. I would like you to press charges against my abuser. Also, I would like to leave with an order of protection today. And the state would say, okay, we're going to put through your complaint, and we're going to go up with you, and we're probably not going to help you seek all the remedies, but we'll go up and you'll at least leave here with an order that says that you're protected and your kids are protected until the abuser gets served. That is no longer what happens as of January 2nd or January 1st. January 2nd was the first day court was open again. So now what happens is those people can go and the state will put through their complaint at 555 and victim witness will help them hand draft a petition, and then they will send them to the civil clerk to go up and get an emergency order of protection. Once the abuser is served, the state can help them, and the abuser is present, the state can then help them get a protective order. But the flaw in the drafting was that the law basically says that the defendant actually has to be there for the petition to be heard in a criminal case, which appears to be a dramatic misunderstanding about how the courthouse that processes most orders of protection in the state operates. So LAS has a project at 555 where we represent complaining witnesses who have children in common in conjunction with their criminal cases to try to seek all the remedies for them. So we are doing, hopefully, a not bad job of trying to catch most victims who have children in common who are going through the process at 555 and making sure that they have someone with them for their case. There certainly are plenty of victims, though, who are having their petition filled out by the state and then are going to do their emergency hearings by themselves. Given that there's an emergency hearing and there's a criminal charge, most of them are getting their orders, but the process is very confusing for victims. So I want you to all know that this is going on. My understanding is that the AG's office is working very hard to write a law that gives emergency relief back to victims and pass it, which would be great because it's causing a lot of problems. But I don't know when that's going to happen, and that's my update.
Yeah, any other announcements, or hopefully I'm not happier on them.
Yes. So I wanted to just make a shameless plug for a clinic we're having on Wednesday, January 24th. Many of you speak to clients every day. Many of those clients are having issues enforcing or getting child support from an obligor, so dad or mom, when they have the kids. If you have a client who's in need of help, you're having a clinic. The clinic is actually going to be, obviously, because this is the one by the Apple, wonderful pro bono clinic. DLA Piper and Blue Cross Blue Shield are going to be working with us. We will actually help clients prepare petitions for child support, motions to modify child support, as well as rules to show cause. So petition for rules to show cause. So if we're having clients who are in that situation and would like to receive help, the clinic is Wednesday, January 24th. Our CCLA is Catholic Straits Legal Assistance, sorry. Our number is in the highlights packet. It's 312-948-6821. They just call us and we can screen them and get them an appointment for the 24th. It is always harder to get clients to come out in the winter. That's part of the reason for the shameless plug. So thanks, everybody.
I'm from the Family Defense Center in Leiden. We have a CLE training that we're doing next Friday. It's part of ICANN, which is the Illinois Attorney Network. I don't know how many of you work with cases that involve the child welfare system, but if you do, this is a training on appellate cases, appealing findings of child abuse or neglect or terminations of parental rights. And we have a really great speaker who is like a national expert on the child welfare system and appeals. And then we also have some Illinois-specific practitioners who are going to give their tips and their viewpoint on the state of appellate law in Illinois right now. So if you're interested, it's a full-day CLE. It's at the defender's office, and it's free. So let us know if you want to come. Lunch is provided. When did you say it was? Next Friday, the 19th.
I will take the mic and I will make even more shameless. I read all this, I'm reading actually right now, all these beautiful descriptions, and I just wanted maybe to put my organization on the map for you because we are quite new. I'm from Highland Park Highwood Legal Aid Clinic, just north of Chicago. If you ever want to make a trip to Wake County, please go and let me know. Call me. We help clients in domestic violence, in immigration and housing. As I said, this is a very, very young clinic. We started in 2015, but last year was kind of transformational, and we had like 3 times more cases last year than the previous 2 years combined. So we are, growing, and there's clearly a need in southern Lake County and North Cook County. So if you ever, need someone up north, just call us, give us, some email or something. We are always happy to work with you. Thank you.